All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for October 7th of 2024. Brad, go ahead.
I want to say two things first. One, this is going to be an awesome show. These cases are phenomenal. I mean, just phenomenal. So I'm so excited. Second, in some of these cases, had there been a policy, we would have had some or true adherence to a policy. We would have had a different outcome in some of these cases.
Would have been no case.
There would have been no case. So once again, if you have not signed up for Kurt's and I must have policies at www.musthavepolicies.com, you are missing out. We have rave reviews. We're going to start posting some of them. We're really excited for the responses we've gotten this early, 4 months into this project. Anyway, okay, let's go. So going to the UK, and I know you had to do this because it was so interesting. We have a firefighter who's sentenced to prison for taking photos of an accident victim. And you may think, oh, there's some law there that is specific to not taking photos, right, of dead bodies, etc., like New York and some other states. I think 3 or 4 other states have.
New York, New Jersey, Connecticut, and California all have laws making it a crime to take certain pictures at emergency scenes. So
exactly. But this one wasn't them, which is, even though it's not United States, it still resonates with me as, oh, crud. So here's what happened. So basically, we have a 34-year-old firefighter who in 23 was working for the fire service, West Midlands Fire Service in the UK. He showed and shared, he took on his phone and then shared on WhatsApp and some others. He shared the photos of the body of the man who was killed in the car crash. And he also made some obnoxious comments. That doesn't help either. So, but here's the deal. What he was charged with, which I'm pretty sure this exists in most states. It definitely exists in New York.
It does in New York. Yeah. They call it.
He was charged criminally with misconduct of public office. So in some states, and I can tell you in New York, like fire chiefs in fire districts and other fire departments are deemed public officers of the municipal entity. So they can be charged with, my belief, this is probably many states, could be charged with misconduct in public office. Usually these are things based on like threats and such. I don't recall even seeing in like sexual harassment cases, and I'll tell you why. I don't normally see in sexual harassment cases this type of charge. And the reason, which is so unique here, the reason that people who assault public officers, who assault others, who rape others, who do steal money, the reason they're not convicted or usually charged with public misconduct or misconduct in a public office is because those duties are outside the scope of their office. But here you've got a firefighter who is at the scene in his capacity as a firefighter, taking pictures, may have been in the capacity of a firefighter, posting them clearly was not, right? But he's still charged. Again, this is the UK, but I'd be real nervous if I was a United States firefighter that this could be, especially a fire chief, when you get to the officer ranks, right? Because I think they're more likely to be public officers than a regular firefighter. But I'd be real nervous based on this. This is groundbreaking in some ways.
Yeah, there's a couple of points to this. One, there was a quote from the prosecutor that I think is at the core of what we have to train our firefighters to do. And that's that we're in someone's home or we're at an emergency scene to help people, not exploit their tragedy for our own humor, for our own
publicity.
Because when I look at a lot of the crap that's on Facebook and Instagram, it's hey, look at me. It's right, like that narcissistic part that everybody's got a little bit there, but hey, look at me. Look what a cool firefighter. Look at the cool runs. Look how awesome I am. And that should really, it should disgust us that we feel the need to do that, or that some of us feel the need to do that. So that, I think, is part of the training that we've got to get folks to recognize that when you are there as a helper, you can't exploit your presence there for your own purposes, your own gratification, whatever it may be. You want to, hey, look at me, crap. So that's sort of part number one. The next thing has to do with the sentence. He was sentenced to 20 months in prison. Now, I'm gonna kind of contradict what I just said. I'm gonna sound like a hypocrite, okay? 20 months in prison. There's people routinely robbing stores in different
That
cities
get less.
where the police are not going to arrest them. Okay. They're doing like real crimes and they're not getting 20 months in prison. This, I get what the concern is. I agree that some degree
But
of
remember, this is the UK, not America.
and I know that, but still, 20 months in prison for this. He lost his job, which, you know, if he's the only person that has ever done this in his department, then certainly. But I have a feeling, my experience, typically he's not the only one that's engaging this kind of behavior. And he might be the only one that got caught,
Right.
but
But follow that up. If
yeah.
the department, bring it back to the US, if the department was aware that he and others were taking pictures, the department is certainly at risk of a 1983, another lawsuit, right? For having a
And we see
known
it.
policy
and
of
we see it.
allowing the taking of pictures and posting it on, right? Posting it on the internet, et cetera.
Right.
So, you know, if this was the
Yeah.
US, this would have turned into a civil rights lawsuit.
Yeah, and it may, you know, I don't get all of the news from the UK. I just happen to get this one. In fact, Billy Goldfetter was the one who fed me this one. I didn't find it on my own, and I appreciate Billy helping me out by,
Thank you, Billy G.
sending me that. But it's an important issue, and it comes down to what we always talk about, right? You got to have a policy. You got to have training on the policy that folks they can't just know what the policy is. They got to understand the why. And the why in these cases are a case like this is Exhibit A.
Yes.
This is the consequence. And there's many other cases. There's a case out of FDNY with a firefighter being charged with official misconduct for posting a picture of a dead person. So point being, we've got to have a policy, we've got to have training on the policy, and then we've got to have our officers act like officers. Okay, not everybody's buddy. You're not there to be everybody's buddy. You're there to supervise and make sure that folks are following the policy so they don't get themselves in trouble.
Right.
An officer that is aware that this is going on, which in turn results in this guy getting fired. You didn't do your buddy any favors by allowing him to get himself fired.
True.
You know?
True. And like you said, he's gonna be like, it happens all the time. Why am I being treated different? And I think the answer to that, by the way, is because of the offensive and mocking commentary that he posted. Probably had he just posted them, you wouldn't have seen such irate.
Well, that's the third part that I wanted to just discuss in that there's irreverent behavior that we engage in. There's a need for humor. Humor plays a role in what we do. Humor in between firefighters is one thing, but not everybody. And maybe he was sharing it, but we've got to understand what the consequences are when our dark humor is overheard by people who are not part of our culture. And they're deeply offended. And even some people in our culture are deeply offended by it. So a number of different lessons in this one.
And let me bring up one. Now, I only have used WhatsApp once or twice, so I'm not overly familiar with it, but it has an important point to it. I think that's a group texting invite app, right? It's not like Facebook where I'm posting it where anybody who's friends with me follows it. You have to specifically, I believe, sign up and say, hey, Curt, you and I have a conversation. It's how I communicate with my mother when she's overseas or whatever, right? And it's not like posting on Facebook. So the point of this is, this may have been just a private conversation, not easily viewable. His comments were 1 to however many. And so again, this is not like posting on Facebook, YouTube, whatever. That's even more, shows how much more serious courts are about your commentary. It just shows what I think the point is that offensive and mocking commentary exemplifies his mentality when he took the pictures and shares the pictures. He intended to denigrate. Had he intended to provide some public purpose like, oh, so sorry for this, please avoid the area, or please our condolences, he probably wouldn't have been in this position. But when you attach your mockery to it. No way. No way. Okay, great. But again, had they had a policy that they enforced, right? Let's go to
policy, training, and enforcement, right? The three-legged stool of liability.
That is really it. And you skip any one of those and you're done.
Any one of those legs of that stool are weak, the stool is at risk of tipping over.
We should create that for our
I have already. I've been using it for a while. It's a good
you. Okay. Yeah. So let's go to Alabama. We have once again, if you want to know how to get arrested, here's a great way. I don't pull over for the cops when you should have pulled over. So we have 2 Alabama firefighters. They're just facing criminal charges at this point, but a firefighter, I think a female firefighter, was driving a fire truck, not to an emergency from what I can tell.
I'm not sure of. It wasn't, the whole thing wasn't very clear from the article that I saw, but at any rate, she was driving, the cops pulled up behind her, the sheriff himself, I guess, and she didn't pull over.
Right. Now, she ultimately, and they charge her with driving at a high rate of speed. So that's where I'm questioning, was this to a call or not? If it was to a call, we'd be in a very different world than not to a call, right? Yeah. If your lights are on versus your lights are not on. But she was also charged with attempting to elude. I don't know if she was kept heading to where she was originally going. One would think she was not, right? She was just driving around and took some turns to avoid. Who knows? Or maybe it was just the speed, right, that signified a refusal
to pull over. Maybe the cop was so close that he wasn't in her side view mirrors, and we don't have, unless you have some sort of a digital camera rear view mirror, you don't know what's directly behind you. So there's a lot of explanations for why someone driving a truck might not see a cop directly behind them.
And I got to tell you, I've been in the officer in at that time in Ariel where the cops didn't know where we were going. We were self-dispatch and they see us flying down the road and we get 911 says there's a police officer behind you. If you are responding to an emergency, please advise. We didn't know what it was about time. And we said, yeah, we've been dispatched. You know, you should be getting the call momentarily, blah, blah, blah. And the cop backs off. It was a state trooper. And I think they were going to pull us over because they had no proof we were going to a call and we're forcing people off the road effectively, you know, pull over. So in any event, so they could have just got on the radio. There's other ways, right? If you can't see him, you can't see him. But here, the chief then gets involved. And now the chief also gets charged because he raised advice. He was asked to leave.
He took issue. He took issue.
And kudos to the chief, I think. As to what he wanted to convey, just not how he conveyed it. And he was asked to leave. He persisted. He started swearing. He then fought back while placed under arrest. 2 out of the 3 are a bad idea. So do not fight back. Do not curse at the police. You know, but I appreciate his loyalty to his people. On the other hand, there's a better way to handle this. Yeah. So if a cop asks you, but it raises a question, Curt. Yeah. I'll hold off on my view till you answer. Yeah. If you're responding to a call where the only issue, this would be the only issue in my mind, lights and sirens, you've been dispatched, and a cop tries to pull you over. Now that, I'll hold my comments. Would you pull over or not?
Well, there's a whole bunch of factual issues that go along with that. If I am responding to a fire, and I see a police officer behind me, I'm assuming he's going to the same place I am.
That was my point, right?
Okay, that's my initial assumption. Now, if he starts passing me, I'm going to be a little bit concerned because I don't know about your department. We don't have radio communication with the police direct. We have it indirect through our dispatchers, okay? Right. But if I see him passing me, I'm probably going to back off. I'm saying, you know, what's going on here?
Right.
And now if he pulls me over, now it's a little bit more obvious what he's trying to do. But I know I've represented a couple of firefighters, and this is off duty. They were driving truck, and they were charged with failure to stop. And, you know, one of them in particular, where the cop was like screaming at this guy who's a firefighter, but he didn't know that. He was off duty driving a truck, but he's screaming at this firefighter, and he throws the ticket at him. And then he actually, you know what
which is assault, by the way, by a police officer.
He said, "Give me your license." So he gave him his license. He said, "You stay right here." And the cop continued going where he was going. The firefighter was off duty driving a truck on his part-time job. Cop pulls him over, screams at him, "Give me your fucking license," okay? Gives him his license, says, "You stay right here." So he waited like 20 minutes till the cop came back, and the cop threw the ticket at him. Didn't even give him a chance to say, right? So we go to court, and we got it all squared away at court. And the cop says, "You know what?" He says, I was working an overtime shift. I was tired. I was cranky. You know, and this was all off the record. It wasn't,
okay.
There was conversation with the prosecution before we went to court. But things happen with cops too, and they've got a tough job. And so, but it doesn't necessarily explain why when pulling over a fire truck, they might have that kind of an attitude. But if I'm driving, one's pulling up, going like passing me, I'm backing off. I'm like, well, because they may be going someplace more important than where we're going,
or to the same place, and they know something we yet don't.
So that's fine. Now he pulls in front of me, or she pulls in front of me. Now it's a different story that they obviously are trying to pull me over. Now I've got to say, I'm responding to a working fire. I'm responding to whatever it is. Just
I'm not pulling over.
So you're aware,
right?
You know, and I got a couple of emails and social media comments on this as well. The laws in most jurisdictions that authorize people to use emergency lights do not differentiate between police and fire. Okay, the laws basically call it an emergency vehicle.
Right.
And they say emergency vehicles, they don't differentiate between police and fire. They also say other vehicles shall yield the right of way.
Yes. Yeah.
So there's some ambiguity, not every state, but the states that I've looked at, there's some ambiguity about whether or not they have priority or we have priority.
Right. And I will say this though. So look, just so everyone's listening to Curt and I, we are not talking about when not responding to an emergency. The only time we're saying there's a question to pull over for the police is if you're responding to an emergency. And even if it's a emergency, which is more of a smells and bells, you use the example of a structure fire, that's not a small difference, right? If timing is of the essence, pull over, or at the very minimum, get on with 911, ask them to communicate with the police. I'm sure they can in some way, and say, we're responding to an actual emergency. Do you need us to pull over? The reason I'm saying that is not to be polite. It gets rid of intent to evade, which is a crime in many states, more than just a vehicle and traffic violation. It's a crime attempting to evade. So that requires intent. And here, if you ask, what's your intention with your lights, you're not trying to evade, right? So, but if you're not responding to an emergency, pull over, right? Accept the ticket, suck it up, and let your chief deal with it. And chief, not like this.
You're right. Chief, the chief needs to speak to the police chief or the colonel or whoever is in charge of the police department, not the arresting officer. But, you know, in this case, it was the county sheriff. So that was the person to bring it up to. But apparently the county sheriff was involved in the original offense, to the extent that there was an offense. So,
okay, now we have a new case, which is what I would say is more of a new application of old law, existing law. There's nothing new about this. In fact, when I started reading, I went back to my law school days. I'm like, oh, I bet I know the answer, and I know the answer. But it's something that everybody, especially arson investigators, maybe fire marshals, code enforcement officers, fire police, all with the authority to arrest and detain, need to understand this case. Not just arson investigators who, right, and obviously police here who are going to investigate a crime. So here's what happened. We're in Illinois. We have an appellate court, second highest level court, and they have ruled in a court decision that the failure of a fire, and I'm going to slow down and kind of explain Miranda and all this to everybody, but they held that the failure of a fire investigator to provide a suspect to arson of a Miranda warning, right? With the Miranda warnings, prior to or immediately prior to an interview, violated the constitutional rights and reversed temporarily the conviction, but ultimately will throw out all of the interview. And now you've got to convict her for arson, which is hard enough without her interview statements. So what basically happened is there was a fire. I think it was a cleaning woman or something, or she was cleaning. There was a candle, according to her. It tipped over. She thought she put it out, which sounds kind of hokey, let's be fair. And the place goes up. But the police get her, and here's the rule on Miranda. When are everyone knows Miranda. You have the right to remain silent. Anything you say can be held against you. Your right to an attorney, blah, 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 right? So, but those rights have to be given if there's an investigatory interview. And there's two parts which are often tried and often issues, more so when the interview's out of the police offices than in, because typically this mistake is not made while somebody's in an interview room, except for here. That's why it's somewhat unique. But the rule is, one, you have to be investigated. All right, you have to be asked questions, interrogated. And two, the one that's at issue here that comes up frequently is you have to be or believe that you are in custody. And if the police officers investigating you give you the impression that you are detained, you may not leave the interview area, and they are asking you questions, that is going to meet the test, which requires Miranda warnings to be given in advance. Why the heck anyone wouldn't give Miranda warnings every single time, whether or not in custody? I've had police ask me questions, I got to tell you, and as a fire chief, and I said to them, are you interviewing me as a suspect? And they said, no, we're just conducting an investigation. I said, about a crime? Yes. And I said, am I free to leave? They're like, yeah. I'm like, good. Then I'm not getting involved right now. I'm like, I got other things to do. Not because I was worried. I'm just like, I got things to do. So I'm like, here's my number. Call me later. Had they said, no, you're not free to leave and not given me the Miranda warnings, they're playing with fire, literally. So here's what happens here. The facts are really important, how the court finds custody. And they look at factors, right? The location.
Brad, the part of this that I wrote, I didn't include all of the facts. And there's some other facts. I don't know if did you go back and read the decision?
No.
Okay, so the decision actually has some other facts. Apparently, she's the wife. The defendant is the wife of a paramedic. Not a paramedic in that fire department, but a paramedic who was friendly with a lot of the firefighters in that department. So that's sort of fact number one. Number two, she came to the fire station, not the police station, for the interview. And her understanding was she was coming to kind of clarify exactly what happened. She said it was accidental and so on. And she was allowed to bring her husband. Now, that's also a factor in terms of whether or not you're in custody.
Yes.
And when they got there, the husband went into the sitting room with the firefighters, and they were doing what, the typical kind of things that watching TV and talking. And he was not permitted to go into the interview room. So that was one thing that was unexpected. And that was a factor. That's a factor in terms of the analysis of whether or not someone is undergoing a custodial interrogation.
Yes, that's a third of three factors is the presence of presence or absence of family members and friends, right, who are around you.
Exactly. So if he had been allowed to attend, that might have been one of the things that tipped the balance, but it didn't. I think another thing is the fact that it took place in the fire station. That's what led them not to give her the Miranda warnings, as opposed to if they had done the same interview in the police department, they probably would have.
Yes.
But for whatever reason, I think it's in part because it took place at the firehouse.
And they look, this is what's called the totality of the circumstances test. I don't know if they use that phrase, but that's what this is. Right. And they looked at that, right? They also looked at these are large police officers carrying guns. They also very heavily influenced that the officers expressed their belief of guilt and were very accusatory. And so she's being treated like a suspect. And so they look at all of these things and one person didn't introduce themselves, right? But they look at these factors to determine, did it appear to the individual and to the police officers that they were in custody? And in the end, they did. So look, there's 6 factors, right? The location, time, length, mood, and mode of questioning, the number of police officers involved, right? 1 may not think you're trapped, 2 do, right? 2 or 3 or 4 people may make it like, I'm not getting past them to get out. The presence or absence of family members, as you discussed. The indicia of formal arrest procedure, such as the showing of weapons, which in this case they were wearing weapons. Physical restraint, no. Booking or fingerprinting obviously would suggest some custody. And then the manner by which the individual arrived. This one probably went, based on what you said, in the accused, in the woman's favor, right? Because she got there on her own. And the age, intelligence, and makeup of the accused. And a reasonable person, the court held, would have determined that they were in custody and not free to leave. And so if you believe, just ask yourself the gut question, if you believe as a police officer that a reasonable person would not feel that they're free to leave, you should be providing Miranda. I can never fathom a case why a police officer, anytime he's talking to anybody other than a witness on a street, right, who's free to leave and he's just gathering notes, right, and writing stuff down. I don't get why any police officer wouldn't give Miranda whenever you're meeting with anyone in a room. I don't care where the room is.
Well, the lead interviewer here was a firefighter, and I think that was another factor. And I think in my book, Legal Considerations, I have another case, very similar fact pattern, where an arson investigator was interviewing someone and didn't give them the Miranda warning. And I really think for those of you who teach classes in fire law, I think a good question is, maybe a true, false, or however multiple choice, but getting to the point that a fire investigator can trigger the need to give Miranda warnings, even if the cop isn't there. A fire investigator, right? A fire investigator could, because it's going to be based on the person's subjective belief about whether or not they're free to leave and whether or not it's a custodial interrogation.
And if you've got a gun right away, or there's a gun in the room.
If they've got a gun, they should be unless they have a
New York State, our fire investigators can carry, and fire marshals.
But if they're then they're a peace officer. If they're a peace officer, then they should be trained and they should be issuing the Miranda warning.
Which is funny because in New York State, there's things called fire police, like there are in many other states, and where we are, fire police are peace officers, but they have only limited powers of arrest if there's a fleeing suspect in a felony who's going to cause harm to another. But you still have that power, So anyway, I think the big thing is the presence of a gun in a room are 2 huge factors, especially the size of the people, that are going to make you feel like you're not free to leave. It is really a case for anybody with the power of arrest. It's interesting. Okay, let's go to Georgia, where we have a magistrate judge. This is a judge who kind of writes an opinion to give to a court, and then the court can rely or not rely on it. We have a magistrate judge in Georgia who recommended the dismissal. Curt, you look confused. Am I doing good on the case?
No, you got it. I'm confused by the decision. I actually don't like to embellish. I don't like to put my personal thoughts out there, at least in the blog. But this was, I don't know where this
is bad
coming from.
Yeah, this is bad. So and you take real issue with this. So I'm gonna recite the facts and let you, because you take real issue with this whole thing. So they recommended the dismissal of all claims that was brought by a division chief. So the division chief sues, right? And the division chief was terminated after reporting sexual misconduct by other chief officers. And the division chief claims that he was terminated by the city as retaliation for reporting that a deputy chief and a battalion chief to the fire chief, and then complained to the city administrator, right? And the first thing that I thought of, hopefully you're thinking of, is, chain of command. You keep going up and up and up. What does the policy say, which I want to talk about? And anyway, and that the fire chief ultimately refuses to address the problem. The court, in its reasoning, said that the chief was terminated for making false allegations, going outside the chain of command, and failing to properly do their job. That was the city's, argument. But the magistrate agrees with it, and basically recommends to the judge to get rid of it. It basically saying that the pleadings on their own don't establish enough for their case, and that and actually, they are so short that they support dismissal. Here's I want to quote it. The examiner's decision of all this was premised upon a police investigation report, which is where you're going to take issue in a minute.
Yeah.
And it says Cox was terminated for a combination of 3 basic reasons. The first relates to violating the appropriate chain of command. The second relates to allegations made as outlined above. We'll skip that for a second. And third, that the chief made false allegations of a cover-up and potentially criminal allegations against the chief and deputy chief, and then deliberately or negligently disregarded requests regarding training, something kind of outside. So the question is, and I'm going to turn it over to you because people should be shocked. Remember who did the investigation here, who they rely on, right? And so well, I'm going to let you take this, but everyone should be thinking, wait a minute, is this a neutral investigation? And then why did the judge rely on that? Curt, I throw this off to you.
Well, the judge, as the magistrate in this case, apparently is saying that he or she, and I'm not sure if it was male or female, but the magistrate is saying that they cannot evaluate the factual conclusions that were made by the hearing examiner. Okay. And that therefore they're bound by whatever factual determinations by collateral estoppel and issue preclusion, which are a couple of legal theories out there that, once a decision is made, you're bound by it. Now, issue preclusion, I think, is relevant when a court makes a decision or an arbitrator makes a decision.
But not an investigator and
not an investigator. And not only that, you've got an investigator that is paid by the city who's a party.
Yes.
So, in other words, if you follow this logic here, this magistrate, then all the city has to do is pay someone to come in and hold a phony baloney hearing. And I'm not saying that this was a phony baloney hearing. I'm not casting aspersions.
It looks that way.
Well, I'm not saying that's what happened here. But what I'm saying is, on this principle, an employer can come in and hire somebody to do an independent examination, which relies upon the police department's investigation. So now you've got the city who maybe has motive to say that there was nothing wrong with what they did for liability reasons. They're trying to circle the wagons to protect themselves from any sort of retaliation claim. And now you take the case to court, not alleging that they made a bad decision, not alleging wrongful termination or whatever like that, whatever the factual basis for the termination was improperly made. But now you have an independent allegation of sexual harassment or sexual basically retaliation for making a claim, which is almost a whistleblower. And I think there was a whistleblower claim. These are independent claims. And you're saying that you can't review those because there was already a factual determination about some of the factual issues. That's insane. That's the kind of logic that I expect courts in Russia to come up with about why they can't give Brittany Griner a fair hearing or a new hearing, because the police officers who arrested her made a factual determination that she's guilty. So we don't need to review it again. No, that's insane. But anyway, I just don't understand where this magistrate
should have been thrown out. That investigation should have been thrown out and not considered in any respect.
Again, you have the factual determination that he should be terminated. Fine. Okay. Right. Now what we want to do is determine whether or not that termination process itself was retaliation. You have to then look at additional facts. There's additional facts beyond the facts that were decided there that have to come in. Also, the whistleblower allegations. So the court should not be bound by that initial determination that took place in a non-Article 3 venue, a non-judicial venue. I don't know.
Look, and this raises a much bigger point of your investigation policy, and this is where I was getting back to a policy. If you're going to appoint investigator, who, and I'm just throwing issues out, who does the appointment? Who gets appointed? And is there a letter? Because I always have one when I appoint somebody as a hearing officer, not only engaging them, saying, we don't care how you find, you owe no duty to us whatsoever. We want you to be truthful. Your payment is not based on anything related to your decision, right? So that letter is helpful. That's a clear instruction to the individual.
It's helpful, but are you going to hire that person the next time if they rule against you?
Maybe, maybe not, right?
And that's why you need an independent evaluation of it in court.
But yes. But how do we at least avoid the indicia, the appearance of bias when we hire somebody? So I don't like this process, but the only process I've come up with is the lawyer picks somebody, not the party. At least that's a half a step removed, right? Yeah. But the lawyer is still biased anyway. Let's be fair. Yeah. The lawyer picking the hearing officer, the neutral hearing officer, is still biased, but at least it's a little bit removed, and we're not picking your brother-in-law or a guy in a firm you work with, right? And one more thing. I typically then share the name and say, if you have any objection to this person conducting the investigation that you believe is biased, let me know immediately if you have reason. Now, they may not know the reason that that person's actually biased. He was the best man at my wedding, or, you know, right? That kind of thing. But at least it gives an opportunity for objection to somebody neutral. Or maybe part of the CBA says, like a lot of arbitration agreements says, we go to the arbitration association and they give us a list and we each choose from the list. And then we have to agree on the ones that we don't object to. That type of thing. But you got to get a neutral investigator. Right. And if you don't, it doesn't help you just because you get an investigation done that favors you, because it's going to look like a cover-up. At worst, the investigation says you screwed up, this shouldn't have happened. Fine, correct it. Correct it. To me, it's like dash cams. At least you caught the violation on camera. Correct the issue. Let's not keep exacerbating the cover-up or give the appearance of a cover-up. Yeah. Anyway, that was my 2 cents.
Yeah, no, I agree. And again, even if issue preclusion applied here, it applied to whether or not there was adequate grounds to terminate, not the sexual harassment or retaliation or whistleblower. That's a separate determination. Those are federal civil actions that need to go to an Article 3 judge, not an independent arbitrator or not an independent hearing officer here. Right. So who's paid for by one of the parties. Selected and paid for by one of the parties.
Yeah, shouldn't happen that way.
We'll see. I'm interested to see. I hope
I think it should get thrown out. I fully think you nailed this. It is so bad on policy, and it's just cowtailing to the agency.
Yeah,
right?
and also just for the department involved, I'm not saying that this chief was in the right or that he was in the wrong. I mean, this is just
not a comment on the department.
This is really about the magistrates, I think, misunderstanding of collateral estoppel and issue preclusion.
Right. And look, you may have done a perfect investigation, but the worst thing that could have happened is you chose someone more neutral, right? And I know no one thinks about who we choose, but you got to have a neutral investigation.
Yeah, and again, even if the person was neutral, it still doesn't address those additional claims. Right. You know, it can't preclude additional claims that go beyond the initial termination decision.
Now, part of this was a pleading issue, I think they said, you know, how it was pled and whatever. So that's on the plaintiff. That's on the plaintiff, I think. But okay, in any event, so you need an investigation policy. And that investigation policy should dictate who conducts the investigation. I don't think, and we won't get off this topic, not all investigations are equal. Did somebody, accidentally back into the garage, which is caught on video, versus did something like this allegedly happen? Two very different types of investigations can be taken different ways, but
that's a great example. Let's use that as an example. Somebody backs into quarters and hits a wall and does some damage, and then they get fired. Okay. And there's a determination. Yes, they backed into wall. Yes, they should be fired. Okay. And that's fine. Okay. But then they sue and they allege that they're actually being fired because of their gender or their race or something else. And now a magistrate's going to say, "Oh no, it's already been decided. We can't look at that again." That's
Right.
crazy.
Two different issues.
It's crazy. Yeah.
Right.
So
anyway, that's why your policy should address this.
right.
Okay, last one.
Unbelievable. Unbelievable.
I don't even know where to start, but it's a settlement. We're going to talk about a settlement of a lawsuit. Numbers speak volumes. This lawsuit, it's a harassment, discrimination, retaliation type lawsuit for
Out of Kansas City.
What's that?
Kansas City, out of Kansas City.
Kansas City. 1.3 million was the settlement, right? Numbers speak volume. So and we're not saying what was true. There is no determination of true or untrue. These are allegations that both parties felt were better not to go to court in lieu of the money. And so the Kansas City firefighter, now, if this is true, if the facts are true, mind-blowing, right? That this could happen. And, Casey's a good department, so who knows? But we have the Kansas City firefighter paramedic with 2 pending employment lawsuits agreed to settle both suits, not file a third, which we'll talk about, in exchange for the 1.3. The allegations in each of the suits, again, mind-blowing. Let's take the first suit, right? This was filed in federal court, Jackson County Circuit Court, state court, in 23. And the plaintiff is female. She is a lesbian. She's over the age of 40, which gets her age discrimination. You have to be over 40. The defendant was the city, and she claims that she's been, this goes beyond abuse, if true.
Well, the first one actually, I didn't think it had a lot of substance to it. Her first lawsuit.
Really?
Yeah, there was like, oh, somebody told me to shut the F up.
You were not normal because of your sexual orientation?
Yeah, well, and at any rate, she had some issues, okay?
Right, and she's told you don't know what you're doing, but it sets the stage.
Once she filed the first suit, now things started getting worse and prompting her to file a second suit after she was, according to her, intentionally tripped.
Right, but let's stop at the first suit for a second, because something happens at the first suit, which I find is critical. Every defense lawyer finds is critical, which is she started seeking emotional treatment for the alleged harm. So one of 3 things happened. Let's see if I can do this. One, she was really emotionally harmed, and this was that. So her seeking treatment is evidence of the harm it was causing. 2, she had gotten a lawyer who said, start treatment. And I've done that a million times as a plaintiff's lawyer. Or, I don't know, 3, but there's
a third one. Go ahead. Let's see if you and I agree on the third one.
I don't want to say it. So you say it.
All right, well, I'll say it. I'll say that she's got issues, and those issues are what led her to need help. And now she's going to point the finger at something other than herself to say that's why. And again, I don't know. I'm not casting aspersions on her. What we're saying is this: when someone goes for help, there's a number of reasons why. They could be bullied, or they could have other issues.
Right. Either they were told to do it, they felt they needed to do it for a legitimate or not legitimate reason. Right. Nonetheless, I normally find, I got to tell you that in my experience, people, even with legitimate injuries, do not always seek emotional help. Okay, but now we get to the second one. And the second suit was filed after she was allegedly intentionally tripped, for which she had an injury. So the person who tripped her is an African-American male. Let me stop here for a second. When the person who does something is wrong, allegedly done something wrong, is a protected class, male, female, age, sexual orientation, gender, race, religion, it doesn't matter. It doesn't matter. I don't care that you're a black, Muslim, Jewish, gay, transgender, whatever. It doesn't matter if you're the accused, right? But in the minds, allegedly, of people, because you're going to hear a comment later that, oh, well, you're a victim of race, black trumped lesbian and over 40 female, right? It doesn't matter. But allegedly, that was what was said to her when she complains. Well, but the complainer, or, the accused is black, so we got to side with him. That's insane. In any event, this coworker who tripped her was an EMT, allegedly tripped her, was an EMT on a scene where they got into it. And This is unbelievable. So let me just read this. The coworker placed his hands on plaintiff and prevented plaintiff from engaging with the patient. The patient, who was mentally unstable, began running around the airport where they were, the airport terminal, creating an unsafe situation. So he interferes allegedly in her treatment, the paramedics' treatment, and this other guy, the African-American male, was just a EMT, and interferes. So she then requests the video footage. Now, the request alone is a strong presumption that what happened is what she said happened, right? She's like, it must be on video, give it to me. But instead, she then is brought into the station. She's interviewed and was told there's an ongoing concern, and she asked for permission to respond to the accusation against her because she's now accused, right? They turned the victim into the victimized into the whatever. And anyway, she reports the March 10th tripping incident, asked why she's continued to be harassed, and the answer allegedly to that, why she's continually being harassed and why the department's not doing anything about it. What's the answer? One, you're beat by the race card, and two, I love this line in such a bad way, she sat down to pee, right? Meaning you're a woman. Allegedly, that's what she said. But I got to tell you, those two lines, if they don't sound like something that she would make up, is going to have a great weight against her. And clearly they settled, so they believed they had a risk of losing. In any event, she made a request for the video, and the battalion chief accused the plaintiff of hiring an attorney to obtain the video. She has the right to get the video. She's a person. She has the right to do it. You're not prevented from your job, nor could you be from requesting a video. So they go after her. And then, as if that's not enough, while she was recuperating from an injury, a firefighter urinated on her personal belongings that were at the firehouse. The DNA identified the culprit, who was subsequently charged with, they figured out who it was, right? And then they arrested that person for harassment and felony.
And
the only
I'm
thing
not
I
sure
couldn't
if
tell
it's
is
the same person as the person who tripped.
That's what I was asking. Was it, or we don't know?
I don't know. I don't
okay.
know.
But it doesn't matter because it's clear whether it was the same or it'd be better for the department if it was the same person, frankly. Yeah. But right, but she claims hostile work environment. There's probably not much more hostile than getting your gear peed on. That probably was the tipping point. Whoever did it, obviously they know, whoever did it, I presume was a firefighter and was at the firehouse, so had access to do that at some point when no one was around, like at night. So I'm going to presume it was one of the on-duty firefighters. I don't know. But that establishes hostile work environment. If it's one or more people, it doesn't matter. But when you have more people, it's certainly more pervasive than just one person doing it. 1.3 was probably fair. This has been going on for a year. So that's probably a very fair number. I just don't understand why the city or the department doesn't step in and say, to the person who was doing it or accused, you're out, you're done, you're on leave, you're reassigned. This is a big department with more than one station. They didn't have to be kept together. You could have easily solved this by transferring other people out of that station and not her, and created a better environment for people who are more tolerative. And that would have been a reasonable partial solution. That's what I would have done, right? At least while you're investigating, break up the problem as opposed to blaming it on them. So anyway, I think my suggestion, I have to tell you, and I've never made this suggestion before, so it's just occurring to me. Curt, what is your thought on bringing in a neutral party to observe, who's going to be a witness, I get it, but bringing in a neutral party to observe the interview, saying, look, they're here to see that they think the process is fair or not fair. And if not fair, we can voice our concerns, and we'll have at least a neutral independent party sitting in the interview, which never happens. Could happen under Weingarten, right? Garrity. But
I mean, my recommendation is that interviews be recorded, and preferably of our own employees be video recorded. So whether you have somebody neutral or not, it's there. And it's clear what the person said. It's clear what the questions were. It's clear what the facial expressions were. The audio recording will capture the words that are said. but not necessarily some of the body language and other things, facial expressions that go along with that. For our own employee interviews, we should be doing recorded interviews, and then you address that way. But in terms of dealing with these problems, I have my class on toxic employees, and most of the interpersonal disputes that develop have at their core either one or two high conflict personalities. We don't have normally well-adjusted people harassing normally well-adjusted people. So whether there's one high conflict person involved in this, whether there's two high conflict persons involved in this, my sense from my experience and my studies is that we've got a high conflict person or two high conflict people involved in this, and the taxpayers end up paying for it.
Right.
That's the bottom line.
Yep.
So.
Yep. All right. Well, that is I think, a phenomenal show. Thank you for the cases, because those cases are so interesting. Each one of them could be a class, but most of them force the need for policies. I just want to end with this, and I'm never going to stop beating this horse. Policies, especially when they talk about things like investigation. It's not an emergency scene. There's no rush. You can have a long, detailed, in fact, it's one of the tips and tricks I have coming up, short policies, long policies, but things that are not a rush, right? Like investigation, discipline, where you're not making an emergency 2-second, the decision can be very long and detailed. Instructional process policies, right? They tell you how to do something, and those should be detailed because I can read it. And things like this, who we select as an investigator, how it's going to be done, whether it's recorded, all of these things should be in a policy. All of it. Frankly, look, a driving policy, if you were pulled over by the police while en route to an emergency, while not en route to the emergency, here's how you react. If it happened, and here's my ending point. When do we write policies? Whenever we realize we haven't given explicit guidance for something, right? And it's never too late to write a policy. Forget this last practicing. Oh, we have past practices. We can't change the policy. Yes, you can anytime you want. Put it in writing. This is how we're going to deal with it. And all of these things, if something happens like, why didn't you pull over? Well, I didn't know what to do. I was confused. Why is there a cop behind me pulling me over? Okay, don't be confused. Here's a policy. If a cop pulls you over, you're not going to an emergency, pull over. Right? I mean, but why not have that policy? Then we could say we trained our people. Now you know what to do. And your point of why do we have policies? To get the conduct we want and tell them in advance what that is. Not to discipline later as the primary reason. Let's prevent the lawsuit.
Discipline is not the purpose of policies. And that's sometimes we get wrapped around the axle with stuff, but the purpose of policies is not to discipline people, it's to provide sort of the guide rails, the basic direction that we want people to perform within certain parameters. Within the parameters of the policy, you're expected to exercise your discretion, but outside of it, we want you staying within the boards.
So I'm gonna add this to our list of very short policies. We have a lot of them, but this is an easy policy to do in 3 lines, right? To tell what people to do.
Policies, training, and effective supervision. If you don't have all 3 of those, you're going to have a problem. But it starts with a policy. And
on the must-have policies for this month or last month, it depends where you are in the process, but dash cams is going out, and dash cams are a great example of this, but the dash camera will help you, right, in this situation to say what was happening, what was going on. You could kind of see real time, at least looking forward, what's happening. Was I speeding? Were my lights and sirens on? You kind of take that out of here, but this is another good one to have a policy on, and that's why I love Curt and my program and product, because it always reacts to current issues in the law and ways we see that could have kept you out of harm. And isn't that what a policy is supposed to do? Keep everybody out of harm.
And one of the topics that I talk about in I have in the past delivered that 2-day policy drafting class. I haven't done it in a while, but one of the segments we talk about is it possible to have too many policies? And there's really 3 factors, and we'll save that for that video that I'll do for you, but for the program, but really 3 reasons why, maybe we don't need this policy. So.
Absolutely.
All
Absolutely.
right. All
Hi,
right. Well,
everyone.
it's gonna wrap us up for another week of Fire Law Roundup. We'll see you all next week. Brad, thank you. And we'll be in touch.